Hi, Valerie.
Hey.
So Michael Levine has his hand raised. Should I make him a participant?
Sure.
Panelist?
And Hamutal is our speaker tonight.
Okay. And I guess they're promote to panelist. Here we go. I think you guys have to click on something once. Oh, good. Okay. You know the drill. Excellent. Promote to panelist.
Hello, this is great.
Hi.
Adjust my camera. Cool.
Michael.
Yeah.
Okay. And now, Valerie, I'm going to make you the host.
Yes.
And I'll be here for a little while. So if you wouldn't mind making me co-host.
Sure.
If you need something while I'm still here, I'm going to be paying some bills. So
Okay.
Very exciting.
Hey, thank you, Mark. And are we recording yet?
And we are in fact recording
Okay.
this for posterity. So
All right, I'm going to put up my
welcome screen. Okay.
screen. Yeah. And Hamutal, I will make sure you can screen share.
Perfect.
All right, yeah, you should be able to.
Valerie, do you prefer gallery view or would you rather have the speaker view?
Speaker view would be great.
Do you want me to do like a test run?
Yeah, can you test share? Because I see a default that the host only can share.
Let's see.
So I unclicked that, but when we changed hosts, it might have re-established it for you, Valerie. So as the host, on the green button at the bottom of the page where it's
Yep. Oh, here we go. One panelist can share at a time. Okay, there we go. It was just like defaulted out and I was like, oh no. All right.
Share. Just granting access. Sometimes our system is very secure and
as it should be.
Yeah. I don't know why it gets like it. I think it always goes to default every time. I don't know why. Is it? Okay.
I'm going to pause the recording.
All right, I have to quit and then reopen it. Okay.
Okay.
Perfect. All right. Let me just try to share again. All right. Yeah, we are good. I just shared. Can you see my screen?
Yep.
Perfect. Okay. How do I cancel?
And then from there, you could go to like full slide or something.
Yeah.
Okay. Okay. Perfect. All right.
Let me just stop sharing. Okay.
Perfect. All right. Thank you.
Sure.
Oh, that's my whiteboard. Don't want that. All right. We'll just give it just a few minutes. We're just gonna give it just a few more minutes. All right, I'm just gonna give it one more minute and then we'll get started. All right. I think we're gonna have some people trickling in, oops, a little bit later. So we'll quickly get this started. So hello and welcome to the February meeting of the Manhattan Community Board 2 Economic Development and Small Business Committee. This evening, my name is Valerie De La Rosa and I am the chair of the committee. And I will get around to introducing the committee and the board members when we start our business session, but I will quickly go over our agenda for the evening. We're going to have a presentation on small business accessibility compliance from Hamutal Lieberman, who's a partner and chair at Helbraun Levey, and I will introduce her formally in just a minute. After that, we will have a public session where we can have questions from the committee, board members, and the public for anything that we heard in the presentation, and Hamutal will do her best to answer or point us in the right direction. And then if we need to go the full 30 minutes or not, then we'll move into business session. Talk about what we've learned, what we heard at our last meeting, and approve our November minutes. And then if there's any new business, we'll do that and then we'll adjourn. So I'm hoping to have you out of here no later than 8 o'clock. But I want to go ahead and get started so we can stay on schedule. So let me stop my screen share. And I will quickly introduce Hamutal Lieberman. So she is a partner and chair of both the litigation group and the trademark group at Helbraun Levey. They are a hospitality licensing and they're a licensing firm that deals with hospitality clients and the cannabis industry as well. And Hamutal is over both the litigation group and the trademark group. She's experienced in litigation involving commercial and business disputes, partnership and business divorce, real estate matters, employment disputes, and intellectual property matters. Additionally, she's also experienced in all pretrial mediation, arbitration, and appellate proceedings across state, federal, and administrative forums. She holds a JD from Pace University School of Law, where she graduated cum laude, and has a BA in political science from the University of Illinois at Urbana-Champaign. Hamutal, I'll let you take it from here.
Great. Thank you so much, Valerie. And thank you so much for having me tonight. I promise I'm not going to keep you too long. There's a lot to talk about, especially when talking about ADA compliance. And hopefully this will just give you a little bit of insight as to what small businesses are dealing with. We see this, especially working primarily with the hospitality industry, a lot. And it's pretty frustrating for clients, and it happens very frequently, and frankly, no one's safe. So happy to give you the basics, and hopefully I can answer some questions afterwards. So let me go ahead and share my screen here. All right, can you see that? I don't think this in presentation. Oh, perfect. All right. So how to fight an ADA lawsuit, and it definitely starts with understanding the law and the requirements. And I'm going to start with sort of giving you a little bit of a, and of course there's a legal disclaimer, I had to, but so I'm going to start with giving you a little bit of a primer about what we usually see, and then go into what the ADA is, and then some tips as to what small businesses can do to hopefully prevent themselves from getting sued, although there's kind of a catch-22 because you can't really prevent it. And frankly, that's with any lawsuit. If a lawyer ever tells you that you can prevent yourself from getting sued, it's an outright lie. But you can put yourself in a better position. So just the most frequent types of lawsuits that we see facing small businesses, but frankly, all businesses, are ADA is at the top of the list, especially in Manhattan and in Brooklyn, but no borough is safe. Secondly, we've got departmental cases dealing with Department of Health, Department of Transportation. Third, we've got the landlord-tenant lawsuits, which were huge during the pandemic. And in the wake of the pandemic, they've sort of slowed down, but it is still we still see them a lot. And then we've got contract disputes with business partners or investors, and employee lawsuits. So each one of these can probably fill up in, hours of time, but I'm just going to give you the primer on the ADA today. So next, what did I do? Okay. As I just mentioned, New York City, but specifically Brooklyn, has been the hardest hit, and with respect to these ADA lawsuits. We, amongst ourselves, call them money grabs and shakedowns. And you'll understand that soon, because the law is written in a way that they're very economically unfeasible to fight. And so oftentimes we're negotiating with a plaintiff's lawyer that is just looking for some quick cash, and it often feels like a shakedown. Tenants are usually responsible for the remediations or indemnifying landlords pursuant to the lease. Usually, unless it's structural, which then falls on the landlord, but the majority of the leases that we are dealing with put the burden normally, and especially on the non-structural issues, on the tenant. As I mentioned, these cases usually result in settlement, but litigation, of course, can occur if you've got a difficult counsel, or on the other side, where you've got a unique space and you can't reach a settlement. Quick primer: what is the Americans with Disabilities Act of 1990? It's a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, transportation, and all public and private places. For small businesses, and particularly the hospitality industry, you're dealing with Title III public accommodations, which means you cannot discriminate on the basis of disability by public accommodations and in commercial facilities, meaning that all public accommodations and commercial facilities must be accessible. So what is the standard? And This is why we consider these sort of shakedowns. It's considered, so the legal term is called strict liability, which means that if you're not in compliant, but you can be, you are in violation of the ADA. It doesn't matter what your intention was. It doesn't matter what your knowledge was. It doesn't matter who owned or leased the space. You are required to make what's called reasonable accommodations. That's difficult as well because it's a subjective standard and it's different for every space and every tenant. So while we're able to advise clients on what we've seen in the past, it's very hard to predict an outcome in the future. There's so many different variables, like I said, based on the space, based on the plaintiff's attorney, based on the financial accommodations or the financial considerations as well. The biggest misnomer is that there's no such thing as being grandfathered in. Of course, we're oftentimes dealing with very, very old buildings and structures. And so one would think, oh, common sense, if this building was built in the 1800s, there, it wasn't accessible, but so I don't have to make it accessible. That is unfortunately not correct. And the ADA still applies to you, even if you're renting a space or own a space that is, built in the 1800s. So let's talk about defenses. The defense that is I guess your best shot is basically telling the court or opposing counsel that accommodations are not readily achievable. Readily achievable is defined as easily accomplishable and able to be carried out without much difficulty or expense. Now, that's also a subjective standard, which you'll now see that's what the predicament is. One person might say, okay, this isn't easy for me, or I can't afford this, while maybe like a larger business owner or an owner that is more profitable is able to make accommodations. So that's a huge consideration in settlement. Like I said, the not readily achievable can have can take form in either a structural barrier or a financial barrier. Structural, for an example, would be, let's say the bathroom is in the basement, and this stairs aren't, and there's no room for an elevator. Not only is, and let's say that the building is not conducive for building an elevator. That's an example of, it's not readily achievable to make this, to make the bathroom accessible. Financial barrier, that the elevator example is also probably a financial barrier to most companies, right? Usually costs $70,000 to $100,000 depending on what type of elevator. So those are the biggest, that's sort of the biggest defense, but it's tough to argue because you're going to have a plaintiff's attorney saying, you can do it. If there's a will, there's a way, figure it out. Like I said, some of the considerations are the nature and the cost of the barrier removal, financial resources, the impact of the facility. If you're altering your space to a place where you're no longer functional, that's an argument to be made. Also, the number, type, and location of facilities this can work against you. If you happen to be successful and you have a couple locations, then more than likely you're going to be expected to or you're not going to really be able to rely on any sort of like financial barrier arguments. So talking about the hierarchy of accessibility, the first is the entrance. That's by far the most important. That's by far the element that we see that's always included in lawsuits. If nothing else, the entrance is usually relied on. Second is access to goods and services. Third is restrooms. And fourth is website accessibility, which is rather new, but very much in play and interesting. And I'll be going through each of those. So common allegations against commercial facilities. Like I said, inaccessible entrance due to barriers, steps, uneven slopes, inaccessible dining area, non-compliant tables with not enough depth or width for wheelchairs, inaccessible bar areas, inaccessible bathrooms, doors, handles, or locks that require twisting of the wrist, inaccessible websites, and failure to provide compliant directional and informational signage. These are the most common accusations and allegations that you'll see against businesses. So I'm going to now walk through and sort of give you an idea and some suggestions, and I call them action items, but these are ways that you can, these are things that we tell our clients to, if you can be proactive about it, this will hopefully prevent you from being targeted for a lawsuit, because oftentimes, again, if a plaintiff's attorney or a plaintiff walks by your restaurant or walks by your store, and there happens to be like one step leading up to your entrance, they don't even have to go in. They can immediately file a lawsuit because they know that it's not accessible. Now, if there was a proper signage that said, please ring a bell for a ramp, that's a different story. So that's one of the ramps. Are portable and temporary ramps are fairly inexpensive. A lot of times we advise clients to keep them in a either behind the bar or somewhere that's like fairly easy to get to, and obviously train your staff or your employees to know what that means when someone rings that bell, or if they see somebody that's disabled or in a wheelchair, to go ahead and proactively offer them to go to pull out the ramp so that they can enter. Of course, permanent ramps, handrails are more expensive, but technically they're more in compliance. So if you can afford it and finances are not an issue, we recommend, that's sort of like the golden standard. And then this is also something that we see often, is that the floors or the door thresholds can be problematic, and they might require a ramp if it's too difficult to roll over one in a wheelchair. Also, wheelchair lifts are an option. We know some places, but they're extremely expensive, and they're not very appealing visually. So a lot of restaurants and a lot of hospitality clients aren't really interested in getting a wheelchair. But if you're in an establishment that has a lot of stairs, that's definitely an option. And buzzers, as I just mentioned, buzzers at the entrance, and signage, which I'll get to, but having a sign that says ramp available upon request, or please press bell to access ramp, those are very easy to accommodate. And also requiring, so there's requirements for easy entrance in a wheelchair, and to be able to, and that's, I gave the measurement 60 by 50, but if there's an easy way to remove barriers, such as moving tables away from the doors or chairs, or if there's, I don't know, coat racks or something that you can refigure without having to completely demolish an entrance to your business, we recommend it. Signage. So this goes hand in hand. Appropriate signage regarding availability. So we spoke about ramps, but we also want to make sure that there's signage for in Braille and outside of bathrooms, just staying appropriate, just appropriately labeling the bathrooms. Again, like I mentioned, a temporary fix or some kind of signage, like if there's if maybe your bathroom isn't accessible, or one of the bathrooms isn't accessible, you can put a sign that says bathroom in the front is located, or bathroom 2 doors on the right is accessible, something like that. And as I mentioned, it's easy fix, print out a sign, put it on the door. Restrooms. So restrooms are by far the most difficult and the most expensive to fix. And oftentimes the entrance is easier to fix. So plaintiff's attorneys focus on that. Restrooms, there's a lot more room for arguing that it's not readily achievable. So things like adding, but there's ways to make it more accessible, right? And that's what we're always trying to strive for with our clients, is these are little things that you can do, and that would prevent, hopefully would prevent somebody from suing, or would reduce the amount of, I guess, non-compliant issues in your business. So things like adding grab bars in the restroom, even as simply as lowering a mirror. There's like certain height requirements of where a mirror needs to start and stop. Same thing with lowering coat hooks, hand dryers, insulating pipes. There has to be a interest, and the ADA is extremely specific about what is compliant and was not compliant. And there's also a lot of ADA advocacy groups that are constantly releasing checklists of, and after they've done polls and things like that. So there are guidance documents out there for restaurants that really outline every single detailed requirement. Same thing, there needs to be appropriate clearance under the sink. So if there's a trash can under there, or if you can change your sink so that there isn't a pipe underneath it, or there isn't a, sometimes there's a vanity. So if you can remove the vanity, that would help. Sink faucets and other twisting motions are not ADA compliant. So think of things like the door handles where you can like slide a hand in, you don't have to turn the wrist to open it. Those are what we're talking about. Again, switch the flush control to the open side of the toilet. That's a very, and you must be thinking these are very specific rules, and they are. I promise you I didn't make these up. And again, having an alternative restroom that you can use here nearby. So if, like I said, oftentimes restrooms are very hard to make ADA compliant, there is, you can offer a reasonable accommodation by saying, hey, there's a Starbucks 1 block away, and that would satisfy the requirement. Dining areas. So this is fairly interesting. And again, I just included this because we work with restaurants a lot, and the community board does as well. But so 5% of tables need to be compliant. So you need to add accessible tables. And so this is really, and 5% inside and 5% outside. The way that a table becomes compliant is if there's an accessible pathway, or if you can successfully wheel a wheelchair underneath the table. So that sometimes requires a special type of table that doesn't have a T underneath it, and it has straighter legs. But again, and usually 5% of the table ends up being 1 or 2 tables. So as long as you've got accessible, 5% of your accessible tables, the rest don't need to be changed. And then also an accessible pathway of 36 inches throughout the establishment. So again, if there are barriers along the way, if your tables are set up in a certain way, you can move them to, out of the way, so you can create a pathway that is accessible. Doors, they must be 32 inches in width. You can, other things that you can do if you don't want to change the entranceway or the door, you lower the locks. And you can also, like I mentioned, use handles that don't require twisting or grasping or clenching of the wrist. So, and then websites. So there are companies out there that help you become compliant. And a lot of people, I don't know if you've noticed this, but there's a lot of restaurants out there. You'll see it's usually on the lower right-hand side or the upper right-hand side. It's usually like some kind of blue circle with a figure of a white person, sort of looks like a stop sign or something like that. One of those like figures, but it's blue with white is sort of the colors that have dominated these applications. And what happens is that you basically, this is what we advise our clients: hire a company to become compliant. There are several out there that know exactly, like I just mentioned, of all of the physical barriers. They are very well versed in the ADA website guidance. But like I said, there's a lot less guidance with websites. The requirement here again is you have to be reasonably compliant. So oftentimes you will be getting, some of our clients will get sued by plaintiffs that were accessing their website prior to when they received, when they became ADA accessible. And so then we're fighting on how many, like what the damages were. But again, like I mentioned before, this applies to websites as well. It's all about strict liability. So if they can point to any point in time that your website was not compliant, you are liable. and there's statutory fines, but the worst part is that it's also fee shifting. So, as I said, and these types of services cost anywhere from approximately $1,000 to $5,000. It's fairly inexpensive, and it's and unlike physical places, it's very easy for one to sit on the website and just type in a bunch of websites and see if there's accessibility or not. So I think that so the oftentimes when we're talking about settling website accessibility claims, we're basically, again, like we're basically ending up on a number, we're promising remediations, just like we would be doing with the physical spaces. So sort of the best way to reduce chances of litigation, we always recommend having us or another firm that's well-versed in this come out and provide an assessment. Ideally for restaurants, the best time to do that is when you're inspecting the space or when you're doing your build out, and just having an ADA compliant professional out there that can advise you and doing things from the start. But obviously not every place has the luxury of starting from either new construction or having the ability to change enough things around that they're not stuck with the layout that they're buying into. What else? Like I said, yeah, an ADA expert. There could be structural changes that are necessary. You also want to become familiar with the accessibility codes. And I said just the action items that I gave earlier are very simple: lowering hooks, lowering mirrors, making sure that 5% of your seating is accessible. They're very doable things. And I say it's reasonable, and spend the time up front so that it doesn't cost you later on. Because again, these things end up being shakedowns because you get a call and they say, hey, on this date, your website wasn't compliant, or on this date, there was a front step and my client couldn't enter the establishment. And that's it. And then there's oftentimes a negotiation as to what remediations we're going to make. But then these things settle. Normally, these cases settle between $5,000 and $10,000. And again, the unpleasant part about it is that the plaintiff's counsel usually just gives the plaintiff like $1,000, and then they keep the remaining part of it. And the theory behind that is, again, because it's strict liability and because it's fee shifting, for us to go in and to litigate whether there's a reasonable accommodation or not, or whether something was financially, like unable to be achieved because of a financial barrier, which is all subjective. You're leaving that up to a judge to decide. And oftentimes they just, you just don't win. We are seeing a trend though with judges that are, cracking down on the pleadings and really making sure that there's merit behind these claims, because they're highly aware of the fact that these lawsuits are filed and then they're just settled on a basis because the law is written in such a way that it's not financially reasonable to fight it. Because why spend $5,000 on legal fees? And I mean, and that the plaintiff's attorney is already racking up there. So you're, regardless, you're spending $10,000 on your attorney and their fees, and then maybe there's a statutory fine or maybe not. I've litigated cases where our clients are, we go all the way, and the court says, okay, well, we understand that there was a, there was a financial barrier here, but we all acknowledge that you are not in compliance. So, you're going to have to pay the $750 statutory fine, but you're also going to have to pay plaintiff's attorney's fees, which of course have now racked up to $7,000, $15,000, whatever. So our best advice is always to try to work it out and settle, so that you're not spending an inordinate amount on attorney's fees. And also like, a little point on this equal service, doesn't have to be the same service. So there's a requirement here also to provide equal service, but again, it doesn't have to be the same service. So we need to, your menu is going to be the same, let's say, or all your services are going to be the same. But again, if you're as long as, like, if there's no bar seating, right? If a disabled person is not able to sit at the bar, but they're able to sit in the same space at a low-rise table, that's completely fine. So that's really it. I know I kind of sped through that and that was a lot of information, but I'm here to answer any questions.
Great. Thank you so much, Hamutal. It was a lot packed in there. I would love to get a copy of that
Yeah.
presentation. I'll reach out to you about that afterwards. Right now, we're going to ask committee members, board members, and anyone from the public if they have questions. And as people have questions, I'll just remark whether or not they're on the board or the committee. So I'm going to go to Ryder Kessler first. He's on the committee. Then we'll go to Robin and then Michael.
I think Michael raised his hand first, so I feel
I
like
was going to go to committee members first, and then
okay, sorry. I
Yeah.
should
no worries.
challenge your you're always on the ball. My name's Ryder Kessler. I'm a committee member. I guess I have a couple of questions, but I'll try to keep it short. I think, the guidance to establishments to avoid litigation is also the guidance to become compliant. So I think that there's a nice synergy there. I guess and I understand that often these lawsuits are meant most to generate a payout rather than because of some true damage. But I guess, like, in the absent, let's say there's an establishment that has a step that doesn't yet have a ramp and a sign outside that says buzz for ramp. If not for a suit, what is the alternative process by which that site would get identified as being non-compliant and then remediate their non-compliance? Is there an agency that's doing independent inspections? What is the process by which establishments are getting identified outside of this litigation pattern?
Well, I guess there isn't a dedicated agency, but there's certainly different city agencies, like the DOT has become more vigilant with ADA compliance, as because they're out there doing searches and inspections and that kind of thing. The DOH will note it, but they're not really in any sort of scope to enforce it. And then also the DOB. But of course, the DOB is mostly in the situations where somebody is doing a complete gut or like a renovation or that kind of thing. There's plenty of restaurants that or establishments that are operating that are never going to run into any of these agencies, frankly. So it really is, it's up to the patrons, or it's up to these business owners to decide and to take initiative and become more ADA compliant.
It's interesting because it seems like that is a loophole in the agency oversight, where it should be in the interest of the public and of the business owners that there be some filtering where these non-compliant issues get, where they get the statutory fine, but not the litigation piece of it. My other question is related, I think, to the DOT part, and I'm sure more questions will come to mind, but I'll stop after this one, which is just how is the advent of outdoor dining during the pandemic of sidewalk roadbed structures and related stuff factoring in here. I won't try to give any given answer, just curious how is that playing in?
It is. It's absolutely, the DOT is running around and issuing cease and desist and notices to correct. And one of the check boxes is not ADA compliant. We've had clients that have had to put ramps, especially if there's if there's a step down into their outdoor structure or whatnot. So the DOT honestly is coming across these a lot more than any other city agency because of the outdoor dining, and they're doing their fair share and cracking down and making these outdoor sheds at least compliant. Interestingly, they have less, I would say the steps would be the most common complaint, because a lot of them are open air, right? So like you're not going to have the situations where the door isn't wide enough, but there have been issues where there's some of the walls are around, you know, the outdoor structure parts. There's like narrowed entrances or doors, and the DOT basically says this needs to be this needs to be ADA compliant, otherwise we're going to shut you down.
Great questions, Ryder. Hamutal, can I ask you to disable the screen share?
Yes.
Perfect. Thank you. Thank you.
Sure.
Great questions. I'm going to go to Robin Rothstein next. She's also on the committee.
Hi, yeah, Robin Rothstein. I have several questions. Valerie, do you want me to just ask like one, or
You could just ask one, and then like as we cycle through, if there's more, then we'll, and I know Ryder had other questions as well.
Yeah. This one is sort of related to what Ryder was talking about. And I was wondering if you could describe any obstacles that small businesses face, if any, when they actually have to, you know, if they're trying to do their due diligence and get in compliance, are they facing a lot of obstacles through certain agencies in order to become compliant? For example, front entrances and maybe some landmarked portions of the business.
So that is interesting. Landmarks plays a really interesting dynamic, and they actually offer waivers, like ADA waivers, or there's a lot of, I think Landmarks is probably the most creative when it comes to this topic. I've seen entrances, I've seen them allow like side entrances that otherwise wouldn't be landmark compliant, but that would otherwise allow like an indoor ramp or that kind of thing. So they're the most lenient with respect to, obstacles, no more, I think, than any other grief that these agencies is already, especially when it comes to building out. So unlike, and again, we're heavily leaning on the not readily achievable, but that's just in the court context. So to your point, yes, they've got to satisfy these agencies, I guess, opinions, you know, they've got to satisfy some kind of subjective standard to these agencies to get sign off. And that's the problem, is that it's very subjective. And sure, and there's, like I said, the ADA is really, really specific as to what needs to happen. And like at what, you know, again, if there's like a 1/4 inch thickness, then that requires a ramp, and that, you know, there's a lot of very specific things that these agencies can lean on. But also, as I said, it's very fact specific because every place is oftentimes unique and there's a different situation. So yeah, I mean, sometimes I've seen build outs being held up because they're trying to figure out an ADA solution, and you've got it's obviously increasing cost. You're having to hire an ADA expert or an architect that's experienced with these kinds of things. So
as a follow-up, I would hope it would be helpful if there was litigation or somebody was, you know, had a complaint, that if a proprietor was in the process of trying to already fix the problem, that would show good faith that they're trying to fix the problem, right?
Yes, I mean, we argue those things all the time, and that's why we, you know, and I've never met a client, and I'm sure people are out there, but I've never met any person or any business owner that doesn't want to be ADA compliant, right? I mean, yeah, maybe it's frustrating, maybe you know, it's caught like, you know, and clients, I had a client recently that was required to change out all the floor beams, right? And it was like $70,000, and she was freaking out because it was going to put her out of business. So I get that a lot, but I never get like, oh, this is stupid or this isn't worthwhile at all. And that's why we give these sort of like low-hanging fruit options for people to at least be proactive about it and do the best that they can within what they have. Of course, the golden standard, that's why we come in and we do an assessment, and other law firms do it too, or other experts do it too. And we give the golden standard and we say, this is in an ideal world, something to work up to, and truly the only way to avoid getting sued, although if somebody wants to sue you, they still will. But we always argue that. We say, look, we're in the process, or we even, I mean, I've had clients sued even after they've hired an ADA compliance officer for their build out. And I mean, that's really frustrating. So it's rough. It's a tough world out there.
Valerie, I have 2 more questions, but I'll let you, decide what happens.
Okay, I'm gonna go to Michael, and then I've got one, and then we'll come back to you.
Okay, thank you for an excellent presentation. My dog is barking, I apologize. What if a location cannot be made accessible and they settle with a plaintiff? What is to prevent another plaintiff from coming along a day later and suing again? Is there any
Nothing.
protection against
Nothing.
a double action? What happens then?
Nothing. It's horrible. It's a tragedy. That's why we are constantly telling our clients to become compliant, especially after they've been sued, because now they're on the radar. And there are lawyers that have been disbarred for going out there and trolling these websites, right? And the court filings, and then going back to these restaurants and these places and these establishments to make sure whether in fact any accommodations were made. Frankly, a lot of these cases don't get litigated. So they just see a complaint and they go through the allegations, and then they go to the establishment. Yes, we've had plenty of clients that are sued twice. And there's truly nothing to be prevented to prevent another client from, or another plaintiff from suing.
So therefore, there really is no protection against double and triple hitting.
No.
Okay.
From obviously the same plaintiff can't sue,
Right.
but the same lawyer can sue, although there's definitely some bad faith allegations. If I were to get a second claim from the same lawyer that I already settled with, that's not fair, and that's not okay. And I would definitely make a big deal about that. But yeah, no, that's why they're shakedowns and they're scummy. We don't,
Right. Understood. Thank you very much.
Yeah, no, great question.
I have a question. I'm going to hop in here. In terms of, and Ryder talked a little bit about this, about the role the city plays. What role does the city play in enforcing ADA? There doesn't seem to be a proactive, unless you are going to lease a new space and you have to get permits and go through that process, but there's really nothing that certifies or any sort of proactive, like before you're litigated against, what role does the city play in enforcing ADA? I guess it does, it's a federal statute. And in terms of, on your very first slide, you talked about tenants are usually responsible. What role does the property owner play in terms of, if that space isn't leased, are they then liable for the sidewalk? Or I'm just kind of curious, like, it seems as though the lawsuit goes to the tenant and is the property, and the tenant is liable, and depends on their insurance and all of that. But is the property owner alerted anyway? And like, what, can you talk a little bit about that in your experience?
Sure, absolutely. So it really comes down to what the lease says. And if there's no tenant then it falls on the property owner. The lease, and obviously landlords here have so much power, and tenants don't have a lot of bargaining power at all. And oftentimes the leases are written that the tenant is responsible for maintaining the space, anything that's not structural. So if there is, but if in my example of like the floorboards, or the baseboards that needed to be changed or because of the slope or whatever, oftentimes what we'll see is, in the best case scenario, the landlord will stand up and they will say, hey, yes, I will help, or I'll pitch in, right? Because that's an issue. And if it's going to be an issue for one tenant, it's going to be an issue for the next tenant. So it's, we'll see a lot of cooperative work there, but if it's purely just maintaining the space, like I said, if it's because the doorknobs aren't accessible, or because there's not enough seating, the landlord is just going to say, hey, this is not my problem, and you're required to indemnify me, because oftentimes the plaintiff will include the landlord in the lawsuit to put more pressure on the tenant. And because tenants, obviously there's this whole dichotomy in wanting to make sure that there's a good working relationship, and there's a lot of strife there regardless. And so there's always a struggle between the tenant and the landlord.
Got it.
And sorry, the city agencies, again, there's just not much there unless you come under the purview of one of those specific examples that I gave.
Got it. And then in terms, really quickly, of websites, you're saying that, so for instance, if a business had their page archived and on the Wayback Machine, someone could go back there and try to find an old page that wasn't compliant, and because you can still access it as an archive, or is that?
So, good. I mean, that's creative. Well, there has to be, so it would have to be, there would have to be access, right? So like, if they're showing me a website from like the 1980s, I'm going to say, prove to me when you got on this website and when you weren't able to access it. So that's a huge part of showing standing, which is, you know, the right to sue. You have to show that you were injured and that you were given that, you know, that access. So, but it becomes a little bit of a gray area where, again, if there's, you know, in the last like 6 months or whatever, or a year. So, and of course the court, you know, plaintiffs are swearing under oath, and there's no reason to believe that they're lying unless we can prove it, which is hard to show. So, but sometimes like at least with like physical presence, we'll have our clients search for security footage. But again, a lot of clients, you know, have taped over after 30 days or 60 days. And so if it's outside that window, we don't have proof. Or, I mean, sometimes a bartender will say like, oh yeah, like if it was like a very traumatic situation and somebody like really couldn't get into the bar, like that's very memorable. But oftentimes a lot of our clients just have no recollection. And so we're always asking for proof, at least a receipt. Show me like that you purchased something or you tried to purchase something or something like that. So made a reservation.
Got it. Thank you. Robin and then Ryder.
Yeah, so I'll ask one of my 2 questions. Is there a business structure that protects owners best from liability if they have a choice about how they want to structure their business, just sort of as a preemptive measure for any kind of liability, but specifically, I guess we're talking about ADA, but
Yeah,
you know, just so in case, just so they don't, you know, in some cases, imagine they get sued and you're talking about small dollar amounts, but I imagine it could really freak somebody out, like this woman who had to, you know, spend 70,000. Is there a way that they can, protect themselves if, you know, just so that if they do get sued, they don't, you know, go underwater?
Yeah, well, I mean, unfortunately, we always recommend single purpose entities, right? You have an entity that's solely the tenant entity. Unfortunately, there's personal guarantees, right, on a lot of these, or if not almost all of these leases. So but the ADA wouldn't be in that situation. The personal guarantee wouldn't come into it, but what would happen would be if the entity, the sole purpose entity, doesn't own anything else, it doesn't enter into any other contracts, it is just purely the leasehold entity. And that's music to my ears when I hear that that's the situation, because again, there's only so much money in that entity, right? And then that gives us my greatest leverage point is we don't have money. So if you want to take a judgment against us and chase us for 7 years, go ahead. Or 10 years, but you know, so that's what I would say. Definitely single purpose entities. Keep a separate operating entity that would be entering into all your vendor contracts, things like that. That way also, if there's any sort of like personal injury issues, and they want us to, you know, then that sort of separates the operating entity from the single purpose tenant entity.
Robin, if you want to ask your second question, if you want to finish.
Yeah, that'd be great. So this a little bit, I feel like this is already a stupid question, but maybe you will say something that I don't already know. So this is a fascinating topic to me because I have an elderly mother. She's really sharp. She loves going out to eat. And, but we are getting, you know, more and more limited, especially she lives on Columbus Circle area. So we tend to go to Hell's Kitchen, which, you know, along 9th Avenue, great restaurants, but old buildings. And some of them have a step. It's most often the step that's the issue. We figure the bathroom before and after the fact, so we don't have to worry about going downstairs to a bathroom. But you start to think about these things when you have an elderly parent. So I guess my question is, we're not litigious or anything. I mean, we're very pro small business. She always loves talking about promoting small businesses. If in the event we see things like, you know, that look a little askew to us, you know, we one step up, and she has very bad mobility issues. She has very hard time lifting her leg up. To you and me, it's like a no-brainer, no big deal, but to her, it's like stepping up a mountain. And I often have to help her. I literally have to push her up the step. So anyway, my question is there a best sort of methodology to make the owner aware, either, you know, not at all being litigious, but just so like FYI, this is happening. I hope you have everything in place to, what are the alternatives for us next time? If you're not in compliance, you should probably think about it. Or do you go directly to the agency just so they get a little slap on the wrist fine that will light a fire? Like, what's the best process for, citizens who want to support small businesses and get them in compliance before a litigious person comes along and, does something scummy, like you said?
No, this is not a stupid question. I mean, I think business owners want feedback on their food, they want feedback on their drinks, and they want feedback on ADA accessibility. Like I said, a lot of my clients would love if instead of somebody being disgruntled and suing, if you can I have the card? Can I have the GM's card, or can I have the manager's card? Can you have him come over here and you can, and just say, honestly, we love this place. My mother's has had a really hard time getting up the step. Have you considered maybe getting a ramp? Have you considered looking into ADA stuff? Again, you could just say this, what you just said to me. I'm not looking to sue anyone. We're trying to help you out. We're very pro-business. We like this place. We want to come back. It's just getting more difficult. And I think that is really helpful feedback. And I wish more people were honest about it. I think a lot of business owners wish that they were honest about it. You could also, if the GM or the manager isn't there, get a card, call them, shoot an email, send a letter. Yeah, I don't think there's a bad way. I think the communication is key though. Absolutely. And you should never feel shy about it either, or, embarrassed or anything like that. There's nothing to be embarrassed about. You're giving them a tip, right? Like, you're saving them. And yeah, I mean, if you want to give them my business card too, that would work. I'm kidding.
Ryder. Thanks, Robin.
Yeah, I have two more questions, and one is very simple, I think, which is, I understand the ADA is a federal statute and we can't preempt it, nor do I think we would want to, but could the city or state pass legislation that would impact or cap or limit the payouts to frivolous plaintiffs, to maybe say, like, if you, walked by a place, saw that it didn't have a step and sued, the max that you're going to get from that owner is, the statutory fine, or would that also have to be federal?
No, I mean, there's absolutely, you'd be subjected to both laws, right? Like, that's what happens with a lot of this federal litigation as well. So, I mean, you would have to, but arguably, if you're in a New York court or New York City, and New York City passed a new law, then limiting and capping payouts, sure, that would be great. I know that Valerie passed along the bill that's like being considered right now. I think it was introduced to the 117th Congress, but regarding promoting compliance and education, to clarify the requirements. And I think that that's great. My only comment on that is that there's no out. It allows any aggrieved person to commence a civil action based on a failure to remove an architectural barrier. And that's, that's, like I said, it's tough. Some people just don't have the money, and the majority of people aren't bad. They just don't have the money. And so I think like passing legislation is key. And I'm always in favor of capping damages. I think that that's a really great incentive to make sure and to weed out the bad faith actors, and to really, because if you're going to sue, you arguably you're looking to make a change, right? You're not, unless you were gravely damaged, but here the damage is they were not able to access a public accommodation or a commercial space, which is frustrating 100%, but it's not like any sort of financial risk. So I do love that. But on the comment on the bill that's being proposed, I would definitely want to see some sort of reasonable compliance standard, that kind of thing, sort of, again, giving at least the establishment a fighting chance to say, we tried, we did the best that we could.
So as it stands, there's no, sorry, Ryder, did you have any follow-up to that?
I have my other question.
Okay, got it. Your hand wasn't raised, so I got thrown off. Go ahead.
Okay. My other question is, maybe you can't answer this, but I guess and I don't want to speak for disability advocates, and I imagine you don't either, but I have to assume that disability advocates also don't want frivolous ADA lawsuits. So I wonder what kind of potential collaboration there's been or conversation with folks who are representing disabled New Yorkers' interests day to day on the issue of frivolous lawsuits that are undermining businesses that are trying to serve disabled New Yorkers. Is there a conversation with those kind of stakeholders or not?
I can't speak to that. I just don't know. But as I'd mentioned before, courts have been more and more sensitive to these frivolous lawsuits. And if any, I've seen judges just strike down lawsuits and just saying, you just don't have enough here, which I think is great. But that's the most that I've seen from my perspective. I can't speak to what's going on between different advocacy groups. I think that would be great. Because I said, oftentimes the disabled person ends up walking away with $1,000 and their lawyer walks away with $7,000, and it just like doesn't make any sense. And they've, and the same lawyer has already filed like 10 other lawsuits, and they're going to get $7,000 and that other, and I mean, and here it is, right? These, I mean, it's offensive, but like they're these like the namesakes of like ambulance chasers, right? They're going to find somebody that's disabled, that's in the spirit to sue, and they're going to make a deal with them, and they're going to say, hey, you'll take 1,000, I'll take 7, I'll do all the work, you're just going to collect the money. And there are people, there are plaintiffs, disabled plaintiffs that are like, yeah, okay, like I'll do it. So it's a tough situation, and I hope to see some reform. And like I said, I'm happy to see that at least courts, if there hasn't been any legislature on it, at least there's courts out there that are, and judges out there that are really trying to crack down as much as possible on these suits.
Great questions. Thank you. Thanks, Ryder. So to confirm, there is no cure period for the ADA.
Nope. Strict liability. You're just in compliance.
You mentioned that word now. Okay, got it. You mentioned that.
Yeah, no, just it's the toughest standard. It doesn't matter. So many times people are like, well, I thought this, or I hired an ADA expert and they told me it was fine, and none of that matters, unfortunately.
And what is the average? You talked about the average settlement. What is the average time this legal process takes?
Well, if you're settling and both sides, the plaintiffs, if the client, obviously, if like, assuming that the client is willing and is very proactive, with which a lot of clients are, and making these changes, what will basically happen is that we'll get notification, or the client will get notification of a lawsuit. They'll reach out to us. We'll immediately reach out to the plaintiff's counsel. And I mean, we've settled these things in 30 days, really. And here's the thing, they're looking for a quick payday as well. And we're looking to, sometimes we don't even answer, most of the times we don't even answer the complaint. And we'll just say, hey, look, like, let's try to settle, let's hold off on this. Let's try to get this done in the next 30 to 45 days. And the majority of them settle within that time period. And that's because we've got clients that are looking to make reasonable accommodations, and you've got plaintiffs that are reasonable and are understanding that there are limitations here. Sometimes it rises to the level of we get an expert to come out and say something's not financially feasible, or we'll show bank statements and bank records and say, hey, look, we have $6,000 in the bank, and this, in order to become ADA compliant, we have to spend whatever, $70,000. It's just not going to happen. I can give you 3 or 5 and we can call it a day, or, we can keep chasing this around and around, and 9 times out of 10, they'll settle. So I would say 1 to 2 months is usually standard of when we settle. Otherwise, if you're not settling within that time period, you're likely to go to court, which is just, that's not fun. And that can take up to 6 months to a year. And that's fairly quick, especially in this court system. But the reason it's so quick is because there's really very little defenses. So the process is, you're just basically like, as the defense attorney, you're just basically being steamrolled the whole time, which is not fun. But
you said 9 out of 10 of your clients usually settle.
Yeah. Oh yeah.
Okay, got it. That's one of my questions. And then real quick before I go, I see Carter has his hand raised, one of our board members. To confirm, your business, you can get a lawsuit on a Monday and be in a process and get another one Tuesday, Wednesday, Thursday. There's no like, hey, I'm in this holding period. So just to confirm,
No.
just don't know what you're gonna wake up to who might be
No.
walking by. Okay.
Right. And that's why, again, we try to give these, we're encouraging that people become proactive in making their places ADA, because you just never know what's gonna happen. ADA compliant. Yeah.
Got it. All right, Carter, you want to ask your question?
Yeah, thank you so much, Hamutal, for coming. We have so many historic old buildings in our community that people are still creating new commercial spaces, some that are shifting uses that were very not as observable to the public that they were commercial businesses, but they're now changing to be, much more visible because they're smaller and the rents are cheaper, so people can be in our community. But some of those are the most inaccessible spaces, and they're in places that are non-conforming to the zoning, so they were never envisioned to be a commercial business, and they present a lot of challenges because I think a lot of the people who look to open businesses there have very limited resources, and so they're looking for those spaces and they just want to open up. And then they find themselves in this bind. And they're the places where the sidewalks are too narrow. There can't be a ramp. The buildings are old. There's not enough space. The storefronts are small. They're bisected by a tenant entry in the middle. How does somebody who enters into a long-term lease, opens a business in those spaces, what do they do? It's even the bathrooms that are already built are the old style and too narrow, and they're all the way in the back.
Yeah, I mean, look, you do the best you can. You make those, if you can change the door handles, if you can do one thing, you do that one thing. If you can get a ramp, or if you can have somebody there, if it's small enough that you have an employee that can watch and can keep eye out for somebody and offer help. To the earlier question, if somebody was at the front door and was helping you help your mother into that, into that establishment, that would make her feel better, even though maybe that's not 100% compliant. So I think you just do, you do the best that you possibly can. And unfortunately, there's nothing that I or any other lawyer, can do to prevent a lawsuit. And that's why these areas are targeted. We will see, there'll be just different areas that will just get hit all at one time by the same lawyer. And because they found a sweet spot, right? And they just go place after place after place after place, and they just sue, and neighbors are talking to each other. And that's kind of nice, because then we're able to sort of gauge like what the settlement range is. But it's horrible. This is why they are inherently shakedowns, because you're trapped in a situation that exactly what you just explained. You're looking at the space because it is more affordable, but yet you're taking on the risk that you might be hit with this ADA lawsuit, and you just hope that you can pay $5,000 one day and just get out of it and have the person run away and leave you alone. But so I guess long-winded answer, but you do the best you can. You put a sign out, you put a doorbell, whatever you can do, you do. That's what I would advise.
Yeah, I guess with the existing businesses, that makes a lot of sense. But for new businesses, it is the lawsuit frivolous. And that's where I just come into, are there other ways? I think of another situation we have a lot of is uneven levels, because we have some hilly areas. So some of the longer buildings aren't always on the same plane. And I just wonder, are those, it seems to me that there's a point where it's frivolous and then it's not frivolous. Accessibility is important, and it's not so much of it's just the reality of what we see. And and can situations continue, and what happens if, just to your point, is the cost too much that it's no longer viable? But at some point, if you're going to have that space as a commercial space, how do you rectify those two sides? And I'm not talking about on the avenues, I'm talking about on a lot of the smaller storefronts. So I guess that's just an open question. And another thing that I heard too, just for other people, I had heard a restaurant that had 2 bars on different levels had more beer taps in an inaccessible area, and the menu, and they actually added them to the front to have the same beer available at both bars. Is that something that is real?
Yeah, well, so I was just saying you have to offer equal service, but it doesn't necessarily have to be the same. So what would be, so I guess moving them to the front bar, if there are two separate establishments that makes sense, or that's extreme, or maybe they just wanted to do that because it was easier, which is great. But what would have been enough? I mean, they could have just simply offered the same offerings from one to the other, right? That was like from the inaccessible to make sure that the people in the accessible only areas have access to those same goods. So absolutely, that's something that you have to, that's sort of like the core of it, right? Like you have to be able to provide everyone the same type of service or the same selection of goods and services.
Great, thanks.
Yeah, no, thank you.
Thanks, Carter. Ryder?
Okay, this is my last question, I promise. I'm trying to think of different levers to potentially pull to crack down on frivolity. And, you know, you talked about judges. Can the Bar Association do anything? Can lawyers be sanctioned for bringing suits that are frivolous? So, and what's going on with that? Because I'm also thinking of what we can be doing as a board to advocate for different entities to pay attention and respond. So yeah, what groups that can be cracking down on lawyers who are acting unethically, what's going on and what could happen?
Yeah, the New York State Bar Association has a grievance committee, and that is open to the public, and you can submit an anonymous request. You can submit a request as being a community board member or just a member of society, and just saying, hey, this is a frivolous lawsuit, or this is unfair, or this person. I mean, as I mentioned before, there have been attorneys that have been completely disbarred because they have sued, or they've filed so many frivolous lawsuits that it's offensive. It's you're violating your code of ethical obligations here of bringing claims with merit. So yeah, I would say that's a great, very creative idea. And that's definitely something to keep harping on, because no lawyer wants to be called by the grievance committee at all. That's not a fun call to handle, I can imagine. I'm trying to think of anything else. I mean, I think pairing up with any sort of advocacy group could be really great, and seeing, again, I'm not as knowledgeable with it, but I know that there's groups out there that are advocating for greater I think education, maybe holding just like, again, town hall meetings. That would be great, just to do presentations like this of, again, low-hanging fruit and things like that. So I don't know about like I was gonna say like maybe I was gonna say like the SBA, but again, it gets very political, and certain areas don't want, certain organizations don't want to like cross over into accessibility. I mean, it's a can of worms. So, but I think that the Bar Association is a great idea.
Would that be the city, like the New York City Bar Association?
So there's a city bar and there's a state bar.
Oh,
So
okay.
yeah, I mean, assuming that these attorneys are barred in New York City or New York State, which the majority, if you're here and you're practicing, yeah. Or I mean, every state and every bar association has every state has a bar association, and every bar association has a grievance committee. So and that's all public information. So I mean, and it's very easy to submit complaints, and they'll conduct an investigation. And so yeah.
Got it. Thank you. We have, I want to ask if are there any other questions from board members, or if anyone from the public has a question. I know we're just a bit over our allotted time for the Q&A, but I want to, if there's anyone from the public that would like to speak, I can allow you to talk. I'll just quickly go with what I see in the chat. I see someone asked, what is required for ADA compliance for website? I know you had action items. Could you quickly just answer that?
Yeah, so it just has to be reasonably compliant, and there's different hearing impaired and as well as like visually impaired accommodations that I know that like there's different when you click on this like sort of accessibility button, it will be able to change the way, like, so the standard is that you're supposed to be able to access the website as any other, it's a public, sort of like it would be a public accommodation or a commercial space. You're supposed to be able to access it regardless of your disability, and be able to functionally use the website as anybody else would. And so if that means that you are hearing impaired, then which and there's sound or something on the website, there's different different settings that you can do to change that, or there's closed captioning or things like that. Visually also, there's ways that you you can press a couple buttons and it'll change the way, I think if you're like colorblind or other sort of blindness, there's like different settings that will change the colors of the website so that it is accessible. But so yeah, that's the majority of it. But again, the standard is very gray, and it's just, you must be reasonably compliant. So
and the action item you had on that slide was about there are consultants that
yes
that know all this, because all there's so much of this that I'm sure doesn't come in our everyday life. So in terms of thinking of all these other different ways that a website could not be accessible, are just not top of mind.
Yeah, no, absolutely. And I mean, really, it's, if you're not, unfortunately, a lot of these, if you don't know someone or if you aren't personally affected, then it's really hard to, unless you're curious and you want to go down a rabbit hole, which is great. But a lot of people, it's just not top of mind, to your point. But I will also say that that the actually, I just lost my train of thought, but I think that there's, I mean, the other tip, I just had a situation with a client that paid for website accessibility, and then she got sued for not being compliant. And I had her go back to her, go back to her web developer that did it and conduct an audit and to compare it with the allegations. And sure enough, their services were faulty. And I said, show me the contract. We can sue for breach of contract. But of course, and I'm sure that this is in most contracts, and I told her, don't sign another contract, making sure, and with these, without making sure that there's a provision that doesn't disclaim liability. But all of these websites, just like accountants, disclaim their liability. And unfortunately, there's no one else that you can pass the buck to. Although I will say that there is some liability policy, some insurance policies that do cover these types of cases, which is great. So that's always my first step too, is call your insurance company. They might be able to cover your attorney's fees and any settlement costs, which is great. That's usually 50-50 depending on the coverage. And then otherwise go to your, go back to your web developer, look at the contract, see if there's any, if they made because everyone makes a rep and warranty that that they're going to conduct the services as applicable with the most recent law, okay, which is great. But if you don't do that, that's technically a breach, right? But then there's also language in the same agreement that disclaims all liability for any ADA cases or any ADA claims relating to website, website disability claims. So again, I mean, I haven't negotiated those contracts just yet, but I can imagine that they're fairly tough, especially there's probably a little bargaining power for the client to get that language out of there. But that was something that I told her, as a small business owner, to try to push back on next time.
Got it. Well, this has been, very informative, and I'm sure we may have other questions, and we'll have this recording posted to our website. I know there are a lot of people that wanted to attend this evening. But Hamutal, thank you so much for your time and for answering our questions, and also giving us kind of these action items that businesses can think about. So I will reach out to you to get that presentation if possible. But otherwise, I just want to thank you for your time, and you're free to go on with your evening. We're going to move into our business session. So thank you again. And thanks to Joseph for connecting us.
Yeah, absolutely. Thank you so much. This was really great. If there's anybody that has any follow-up questions, I'm happy, shoot me an email. Valerie has my contact information. So
Great.
pleasure to meet you all, and see you soon.
Thanks.
All right, bye.
Great. Bye. Thanks, everyone. I just really great questions this evening. And so I just want to open up if anyone has any comments about what we heard and kind of where we can go with this, like as a board to address this. You know, I think we're missing one piece of the puzzle here, a very critical piece. And I know it's something that writers brought up, and we have it in our 1H first half of 2023 programming, which is to hear from disability advocates. Not all of these lawsuits are frivolous, and we're focusing on the serial plaintiffs, but I think, and I want to hear what others have to say on that. I think that really before we can write a letter, or I feel as though we really need to hear the full picture. And I've got some ideas. I know writers shared a resource with us before. When I went on the accessibility, the ADA walkthrough last year in Chinatown, with it went through parts of Chinatown that were in CB2 and CB3, and there were two. There was arts with disability, or Art Beyond Sight was one, and then Project Access for All. Those were the two organizations that were on that with. So I might start there. Maybe we start there and see that, because there was the general thought there that they weren't a fan of, and I'm not going to speak on their behalf here, but that no one was winning in this serial plaintiff. But I think that there's clearly, the ADA is there for a reason. It has been for many decades. And as you heard from the questions tonight, whether it's with outdoor dining, whether it's with within a historic district, a landmark building, and then even thinking from the licensing perspective on SLA, this issue touches so many different parts of the board and the work that we do. So any other comments from anyone on what we heard tonight? Carter, and then Susan.
Yeah, one of the things is people just don't know about this. And, you know, it's not a thought process when, yes, if you go to certain resources and you educate yourself, but when you're opening a business, this is not probably high up on your priority list of what could happen. But when it does happen, it can be devastating to your business, particularly if it's in your first couple of years. And that's why, you know, I think about this with a lot of what we're seeing of businesses opening in sort of non-traditional areas that are a little more high profile. Those are our small business owners that aren't super capitalized, that put together all their resources, all their money to get going, order their inventory, whatever it may be. And then this comes up. And, you know, one of the things is that the fees and for settlement is equal to a big, well-capitalized business, right? Or a super small business. The settlement amounts are the same, and it's going to hit small business owners much more significantly. And I don't know how people get the word out, but in an area like Chinatown or here, people see long-standing businesses in these spots and they say, well, hey, we can be here. And so we're just going to do it. And, oh, you know, my neighbor doesn't have to worry about, but these little small things can make all the difference in whether you're accessible or not, whether you have to tear out your bathroom in a place and make it bigger. And I don't know how we better get out the word on that, but this is very much an issue for our community. And it was sort of premised the question I asked. You have an old business, okay, we get it, you know, particularly one that's been around a long time. But once the new business moves in, it seems to, and maybe that's not legal or, from a legal theory, but it seems there's a higher obligation and the landlord is getting the benefit of leasing the space. And then they're inadvertently pass the cost on to the tenant because they're not responsible for anything. And I just bring this up because this, for us, it's not as big as an issue in areas where the rents are less, because there's more money moving through a lot of our businesses. So some of the costs may be manageable, but in other areas where the rents are much lower and the costs are the same to make these changes, I mean, that's seem like it just wipes things out entirely for them. And that may be some of the edges of our community, like Chinatown or some of the other areas. But I just bring this up because it's very frustrating. You see people just moving ahead and, it's not, how do you bring it up to say this is something that could undo your whole life investment? And they didn't mean to. So I just throwing that out there as some of the thoughts of why this is so complex. And I'm not talking about frivolous lawsuits too on that. It's just continuing a condition without improving it over time, and who bears that cost.
Those are all big, those are big questions. And good food for thought. Thank you, Carter. Susan?
I really want to second, that need to hear from advocacy groups and individuals from the disabled community, because the one thing that I really took away from listening to this is not only are small businesses being taken advantage of, but the disabled community is being taken advantage of. It's being used, individuals are being used as a means for, unscrupulous lawyers to line their pockets. And the quickness of the turnover of some of these, of concluding, a lawsuit is really, to me, prima facie evidence that there's no intention to improve a situation. We're not talking about situations where a disabled person was really, experienced some sort of harm or, unequal treatment and is looking to resolve it. We are really looking at they are being used as well. And, we're really on the same side of things. We have small businesses that, and, Hamutal was right. People really do want to comply with this. It makes their businesses better. So we're really all on the same side of this. The question is, how do we bring people together so that, to stop the abuse and to, at the same time, to promote, remediation, improvement, just education, so that people can do the best, especially like in our community, what's the best that they can do under the circumstances that they have. And, it's really infuriating. It's the way the law is written right now, it really doesn't, it's just inviting abuse, and no balance. So I would love to see more of this. And I think there's real opportunity here for, a part 2 of this.
Part 3, yes.
3.
Yes, thank you. Thank you, Susan. Appreciate you. Ryder, before I get to, just thinking of Carter's comments and then what you were saying, Susan, is it, and then kind of thinking about Ryder, what you prompted earlier to Hamutal about what can we do or what can we do on a city or state level? Is it asking for more funding? I'm trying to think of like the budget cycle, which we will, is it asking for more funding for education, from SVS and MOPD? And I've been in contact with the MOPD, the Mayor's Office of People with Disabilities, General Counsel, and they're looking to come to us a little bit later. And I think they're ramping up a big citywide effort in this. I shared that businessaccessibility.nyc site that does address lawsuit ADA lawsuit issues and whatnot. But, is it asking for more funding for education from those? I don't know. So just throw that out there. So Ryder and then Mills.
Yeah, I think that's a good question. First, I just want to acknowledge, I do think a part 3 with disability advocates, it makes a ton of sense. Maybe the mayor's office for people with disabilities representatives can come to that too. And that can be the kind of 3rd chapter of this. I think that would be great to inform a resolution or recommendations we would make about funding for education, about, non-litigation related enforcement, about legislation to cap fees, about sanctions of bad acting lawyers, whatever. So bracketing that in terms of, the point that Carter raised that we've all been talking about of, what can we do as a board just to increase education for compliance, because compliance is a good in itself and also happens to be protective against frivolous lawsuits, but it's just something that is good for the operators and the community and disabled New Yorkers. I do think what are the points at which new hospitality entities come before the board? Well, maybe they're coming to a SLA to apply for a license or something, or change in ownership. Maybe the SLA committees can be giving out a checklist about ADA compliance best practices to everyone who comes before us. There are things that we can do that don't cost any money, but where we can be surveying the small businesses in our community just by saying you're here for SLA, but take this with you, and it's quick primer. Maybe we can be doing some outreach to and with the bids that overlap with CB2. I do think there are things we can be doing to get the word out in a way that is within our mandate and doesn't cost us that much time and money, to help proactively empower these operators to identify and correct these things before anything happens.
Great, thank you. Thanks, Ryder. Mills, operator and committee member. What are you thinking from what you heard, and what's been your experience?
So
and if you any other comment you have to make, of course.
Sure. My comment was going to, Ryder took the words out of my mouth. I was just thinking about ways in which we can engage the other committees that interact with businesses, because quite frankly, as an operator, the ADA piece was so typically, and I'll give everyone sort of the stages. You oftentimes have to sign a lease before you can engage, so you're already committed to the space, and then you're moving forward and you're stuck at that point, and then it's remediation. Typically with storefronts, who I imagine are the most affected by this ADA rule, if you're making any changes, it typically, if it's historic, then that's one route you have to go. And if it's not Department of Buildings, you usually file your change of plan with the Department of Buildings, and you often have to engage an architect who signs off on that file and submits it. So at that point, you just assume that what you have is copacetic, and that because DOB has signed off on it, that there are no issues there. Now, obviously, what's submitted to the Department of Buildings and what actually ends up happening when there are design elements, what you assume to be design elements that are not structural. Mm-hmm. And I think from that standpoint, most business owners are truly ignorant of it and assume that they're operating fine. I think Carter's point, if you look at, in particular, CB2, the number of pre-war buildings that we have and sort of what were deemed sort of 5-story walk-up tenement conversions is probably more so than any other portion of Manhattan, apart from way uptown. And I just assume that these businesses that are being hit are just really ignorant of it. And again, I think if there's a way we can provide information and guidance and get them, use it as a talking point throughout any step that they touch us as a community board, I think that's the most proactive thing that we can do and effective. That was my.
Thank you for that. And hearing, Mills, while I've got you here, when you said you file change a plan with DOB, and then you're kind of like, all right, like they have no, there's no sort of feedback they're going to give you that says like, hey, this might not be compliant.
Nothing at all. In fact, usually it goes back, it gets recorded, and that's it. And then what may happen and is they'll come and do a site visit. So if they do a site visit, that happens rarely. I think they look at the scope of work and they pick the most pressing, right? If it's like a massive conversion, they'll go to that one. But if it's something as simple as changing plumbing or doing something, you're just waiting for the inspection may or may not happen, and you get the green light.
So they're not giving you a check mark on ADA compliance. DOB is not.
I don't want to say yes or no.
Okay.
I just haven't, there's never been anyone who specifically spoke on, and I've been through 3 of these now that's spoken on this issue. That said, the spaces I've had have gone through that conversion already. So I haven't received.
Got it.
And I think the main issue is depending on what you're going into lease. If you have anything that's leased after, I want to say, I don't know the exact date, but sometime in like early 90s, if you likely have already gone through that massive conversion and checklist of ADA. But as you know, with the pandemic, there are a lot of businesses that had that sort of 30-year plus history. So there are a lot more new leaseholders that are entering our community right now, that are taking over spaces that may not have gone through that process in the last 20 years.
Got it. And you have experience with this in CB2, right?
Yes. Yeah.
Just so everyone knows.
Yeah.
Okay.
Yeah.
Which I knew that, but I just want to make sure everyone knew that. I mean, in hearing that, and Carter, I don't know if you have additional comment or not, your hand's still raised. Is this, and I offer this to the group listening to what, you were saying, Mills, and then having Chandler Forsyth, who was with us earlier, had shared some links from the Landmarks Preservation Commission about a storefront compliance, which would be like in a historic district or a landmarks building. Is this a larger thing in addition to a letter for, or a resolution to our elected officials? It sounds like it's DOB, it's LPC, Department of Buildings, Landmarks Preservation Commission, Mayor's Office of People with Disabilities, and Department of Small Business Services. And I don't know how to get SLA in there, but those seem to be the agencies that at some point have a touch point with this issue, at least from a licensing standpoint, at least, as if it's a hospitality space, it's SLA, DOB, LPC, that, maybe warrants some sort of town hall about this that would be with like the other, maybe the other downtown community boards. I don't know. I'm just kind of throwing it out there. Like I mentioned earlier, I know MOPD, there's Office of People with Disabilities, and Small Business Services are working on their own type of outreach, but I kind of just thought that kind of where my head was going with what I was hearing. Michael? Michael Levey?
Oh, yeah. Do we have anything on our website that lists or gives any reference or any way to access the ADA standards? It never occurred to me. Do we have it on a website?
That's an excellent point. I've started to put together a list of links just to have a freestanding page that would be associated with our site. So that's a great idea. Thank you.
Good.
Mills, did you have additional comments?
Yes, actually, off of Michael Levine's point, I was actually thinking if we could have a standalone page for economic development and small business, just that serves as a resource. I think one of the number one issues that one faces when they're starting a small business or entering our community is sort of where to go. And I know we've talked about this before when we had small business services come on before, but having gone through this process for one of my newer businesses over the summer, I can tell you that it felt very disorganized in terms of where, you know, which agency to go to get which information. And it's not always, it would be wonderful if there were a one-stop shop, at least as a service we can provide. And I think, Valerie, you raised a good point about having a forum of sorts. And I wonder if we use that as an opportunity to talk about a myriad of issues, almost like make it a Lollapalooza of forums of information for small businesses in CB2. Because I think there are a couple of issues that have come up that we've discussed on this committee that would be relevant, even from the sanitation issue with, you know, commercial businesses, and the items that were coming up even during the reopening working group regarding the sheds and how they're operating. And I think if we host sort of a mega event where we can go over these pieces, I think small businesses would appreciate it and at least be informed, and also understand where we stand on some of these issues and where we can be of value.
All great ideas. Thank you, Mills. We do have a small, but I think what I'm hearing from Mills, it's kind of like a how-to, like you're starting a business, here are resources. We've got a page with economic development and small business materials, which is more like economic indicators, and I haven't updated it since last year. And it's got a list of all the bids, but it's got some entrepreneurship resources and job skills and workforce development and city agency, but it's not as direct. And I think that I'll put a link to it. I think what I'm hearing is a page that's a little more an additional page where it's like starting a business in CB2 ? And it's kind of more of that direct resource that maybe links to like the city's like one-stop shop business. I don't know if that page has been set up, but also has some specific CB2 related information, like about the storefronts in historic districts, where it's more of that one-stop shop and not just here's overall economic stats and whatnot. Thank you. Carter put that in the chat. There's also some other great resources in here that Mark put in. Mark, did you have a comment? I saw your hand up. I wanted to get to you. I don't know if he left yet or not.
Here I am. I just wanted to,
Yeah.
I threw in the connection to the United Spinal Association because they were about 5 or 7 years ago, there was another flurry of these predatory lawsuits.
Mhm.
And they actually joined with business owners who were fighting against these lawsuits, because the Spinal Association said, if you're going to spend this much money, actually create something that fixes the problem rather than just paying legal fees to a lawyer. And so they were an unlikely ally in this fight. And so I included their information just in case it might be worth reaching out to them again. Their view of this may have changed over the years, but it's one more place to look, in addition to the Mayor's Office of People with Disabilities. Thanks.
Wonderful. Thank you so much. Guys, I know it's 8:10 and we've gone just a little bit over my promised 8 p.m. time, but I feel like we're having a really good discussion. So I'm going to quickly round it out. I had sent over some city, state, and federal level updates on this issue. The state one was more around, there's op-eds like reaching out to Tish James, the New York State Attorney General on this issue, and the state's Office of the Chief Disability Officer on these frivolous lawsuits. So I'm just kind of throwing that back out there in the discussion. And then as Hamutal mentioned earlier, I had sent her the bill, and I sent a link to the committee on the House Bill 77 from the last 117th Congress, 2021-2022, that was looking to address having the DOJ. Again, this gets back on the federal level. So I'm going to reach out to Dan Goldman's office and just see for this next panel, if there's any sort of update or statement from the congressman's office, and also reach out to Greenwich Village Chamber of Commerce, who sent a letter. I know they've addressed this issue. They're actually one of the first organizations to reach out to me about this issue in our district. So it sounds like the consensus is we want to have this third part of our series, have hear from the disability advocacy community, and then we'll see what our action item is in terms of a resolution, a letter, who we're reaching out to, what do we want to accomplish, and what are the other steps that we can push our elected officials on at all three levels, what's possible. And then also, it sounds like we want to get some resources put together on our website. Thank you, Robin. You shared some great resources in the chat. So before we move to any new business and then adjourn, I'm going to, Susan, did you have anything you'd like to say?
Yeah, I mean, all of those entities that you mentioned are great. I just, putting this together, we should make sure that there really is a representation of what goes on very locally for us, because we do face particularly, added complications by virtue of, our neighborhood. The same things that make our communities make it wonderful, add an extra level of complexity to this. So whether it is local chamber of commerce, whether it's bids,
Yes.
whoever's dealing with that, because this has to be really local, as well as all those commonalities, if people are going to make their decisions effectively.
That's a great point. That's a great point. What are the bids hearing? Are they hearing it from their membership facing this issue? And right, making sure that it's true to the needs of the community.
We want to, look, we all want to see improvements. We all want to see maximum accessibility where it is possible. And only by, talking to people who've got their real feet on the ground are we going to be able to, help, forward that kind of information and education.
Thank you. With that, I think I pretty much summarized, and I see there's a comment from Darlene. The more immediate cure would be to get a bill to allow a cure period on a complaint filed in New York. There you go. One thing that had been suggested in addition to the disability community that I had heard from another board member is, would the committee want to hear from one of these lawyers that files these lawsuits? I'm just throwing it out there for discussion, not that we necessarily want to give someone a forum. Susan, yes.
Okay, not so much to hear from somebody who makes this their livelihood, but to hear from lawyers who have represented disabled people who have suffered, and see if what's happened to them. Has it become harder for people with legitimate issues to then get their justice in court, and are they being deprived, is the system now being worked against them? So there've got to be people who have legitimate, legal actions. Let's find those folks and hear from them, because I'm sure they don't like these, ambulance chasers either.
Excellent point. Excellent point. Is it possible to get some sort of bill to allow a cure period for a complaint filed in New York? Is it possible to do that for a federal statute? I don't know who to ask that question to. So I'm just kind of throwing it out there because that's sounds like a good idea. But all right. It is 8:16. I apologize for going over. Is there any new business? Any other new business anyone wants to bring up? I have our next meeting as Wednesday, March 30th. I know that our meeting, we go, we kind of go a month after the cycle of our full board business. So, likely if, we have this in March, then maybe we have something to bring to the board in April, unless we have any other additional business that we need to do around it. So with that, I'm going to adjourn this meeting at 8:17. Thank you, everyone, for your time this evening, and I will send out the minutes within the next couple, maybe give me like a week or so, and I'll get those to everyone. Thank you.
Thanks.